can, my dear friend and colleague, Ruti, introducing the speakers and engaging in conversation with them, but I thought it would be sort of remiss of me not to introduce her. Ruti is the Ernst Stiefel Professor of Comparative Law and the co-director of the Center for International Law at the New York Court School. She is a leading human rights law scholar and the expert of human rights law and the foremost book on the question of justice. She has a vast body of research and scholarship, and her latest book, which we just celebrated, is entitled Presidential Visions of Transitional Justice. So that's just a very, very short, abbreviated bio of Ruti, who will take charge of the conversation, and then Jack will be comment. Thank you. Thanks so much. Yes.
Yeah, great.
It's on now.
Yeah, it's on now. Yeah, great. Great. So, end of a wonderful conference, and kudos to Penny for organizing this and to all who have spoken so far. And I would say that we've heard a very rich analysis of historical approaches to this question of constitutional erosion and comparative, and talking about issues of constitutional culture and structure and interpretation. And all of the panels have deployed Jack's vocabulary, Jack's discourse of constitutional crisis and constitutional rot. And I would say that the discourse has helped us at least, raise the right questions and analysis, but anxieties remain. And I think the conversation, hopefully ending this conference, could address that. And that is that the discourse would seem to only get us so far in terms of what is the answer, okay, where we're going, all right? And so I think we have a wonderful last panel here on this question of where we're going. And the two scholars that we'll be engaging with have engaged with these topics in an interdisciplinary way. And I think this is very important with regard to, what kind of dialogue or engagement can work. Kim, to my immediate left, most people know, Kim Lane Scheppele is the Laurance Rockefeller Professor of Sociology and International Affairs at Princeton, and also at the University Center for Human Values at Princeton. However, and she has a wide body of work. We met during the mid-90s in what was a very heady moment in Eastern Europe. Spent lots of time in Hungary, and Kim became really the expert on comparative constitutionalism after the fall of communism. And really, I would say, for those of us who do comparative work, it often feels very much at the periphery. But I really think that at that time, you brought it to the center of our.
The world brought it to the
The world brought it, and we may be back. We may be back, and certainly very positive news coming out of Hungary recently. So that is Kim, and she will be bringing us a sociological perspective and vocabulary. And Jack, to be introducing Jack at the end of a day, which is celebrating Jack, seems like, I don't know, the cherry on the whipped cream on the sundae. But and most of you, of course, are friends of Jack's and colleagues. I would say that, like Kim, he's been promoting really public intellectual life regarding constitutionalism, and that both of the speakers share that the wish to not just be committed to the ideals of constitutionalism, but to create more spaces to promote engagement on these issues. And in addition to his most recent book, Memory and Authority, the uses of history and constitutional interpretation, which Jack reminded me at lunch we were supposed to be talking about, so at least I raised the title for, and maybe in the future we will, be talking about it. The other, I think really important site that he's created for us is balkanization. When I first heard the term balkanization, I thought, fragmentation, the Balkans. Balkan politics, I'm sorry, but that was I thought maybe Jackanization or Jack's blog or Jack's coffee blog, whatever might have been better. But anyway, that's what it is. That's what it is.
Great.
Yeah, Jack of, well, we could go work with this, but it is balkanization, and obviously it took off, and he's, like him, written widely and really promoted junior scholars in this area. And so let me turn it over to these two real, public intellectuals of the area of constitutional values and constitutionalism. And where are we going? So each of them has a question, and I might ask one too at the end, and then, we can either open it up here and then martinis as Penny has promised. So Kim, I think,
I get to ask Jack first.
Yeah, you do.
So
Yeah.
I'm gonna
Okay,
take
yeah,
the microphone,
yeah,
but
please.
so I actually sent Jack a question in advance, and true law professor I'm gonna change the
That sounds
question.
so Romanian to do it in advance.
Yeah, true. But also because we've had a whole
So this is
day.
bait and switch?
It's a little bit bait and switch.
Okay.
yeah.
Because actually I want to recall some things about you that people haven't said yet today. So Jack
You
and
mean
I.
my criminal convictions?
No. I knew Bar mitzvah. No, but actually, I wanted to recall an element of Jack's past that people haven't referred to, which was your very first writings in this field.
My
in
blue period.
Your blue period, right? Your Missouri period, actually, in which you were doing a lot of writing in postmodern theory. And I have to keep thinking that influenced a lot of what you wrote later. Because once you get into there was a thing called theory back in the 80s, right? Which was, it started in literature departments and then it kind of seeped out like, oh my God, a text was not stable and it depended on its readers and on its audience and so forth. And Jack was one of the first people that brought all of that into the legal conversation. Actually, those were a lot of your earliest publications. And it seems to me that a lot of what you've been writing about since is making more concrete in areas of doctrine the insights from the more theoretical pieces that you wrote at the beginning. So I wanted to ask you a question, which I didn't give you, but since it's about you, maybe you would be the expert on answering this. One of the things you and Sandy wrote, which I keep quoting over and over again, is this idea that constitutional ideas that may start off the wall can get on the wall. So the postmodern question is, why do you think there's a wall, right? But the other question is, we're in this moment when constitutional ideas are just changing so rapidly. How do you understand how that process works of things that were sort of
How do
off the
things
wall?
move from off the wall to on the wall?
Yeah, but also vice versa, right? There were so
From
many
on the wall to off
constitutional
the wall.
ideas that we took for granted that are now being so deeply unsettled that, we don't even dare stick them in legal briefs anymore, right? So how does that process work? And does your early postmodernism help you think about that? How about that?
I would answer that part of the question, which I wish to answer.
Okay.
I'll just start by saying that my colleague Sam Moyne routinely refers to me as a former crit. He says he was a crit, but then he sold out.
Yeah, he doesn't understand that it's all the way, anyway. Never mind.
And
It's not
I
my
find
first
this amusing.
disagreement.
I find this amusing because, as you are right, that I'm still the same guy. I'm still thinking about the same thoughts. But I'm thinking them in different venues. I'm applying them in different ways. And of course, if I had continued to write in the vein of the critical legal studies tradition, it would be completely irrelevant. So if you want to write about stuff, you got to write what's happening here. And so that's what I've done. So there.
Okay.
So yes.
But I still hear the echoes. I don't think they've changed, actually, in that regard.
Well, no, I'm still working on issues having to do with change, interpretation, ideology, social mobilization, right? Social construction of reality. All the things that I wrote about when I was younger, I'm still writing about. I'm just writing about a very concrete context, which is the political context of constitution. Okay, how do things move from off the wall to on the wall and back?
Yes.
So actually, I was going to write this up as a chapter in the next book I'm writing, but this is a good intro. If you had asked this question in 1980, when I started writing scholarship, the question would have been posed as, well, is law indeterminate or not? Is law determinate or indeterminate? And this was the whole question that was raised by critical legal studies. And I have found that this question is not helpful precisely because it treats law as a free-floating object which can have the property of being determinate or indeterminate, when in fact law is a social phenomenon by people and groups who are engaged in various forms of political entrepreneurship and struggle, you see. So the real question is, how do things that seem determinate get unsettled, and how do their opposite numbers seem somehow to become more reasonable, or at least as reasonable as the things that they are displacing? And the answer has very much to do with social groups and persons. So if you think about legal claims, it's the thing to understand about lawyers and judges is they, however much they are engaged in a discourse of power, they believe they're engaged in a discourse of reason. And they believe that above all, they are reasonable people. They are professionals. They engage in reasoned discourse and they make reasoned arguments, and they are reasonable people. So the major constraint on the kinds of claims making that is possible at a particular time is what other people that you are talking to think is a reasonable claim, what is within the boundaries of what a reasonable person could disagree about. And that which is beyond the boundaries of what a reasonable person could disagree about is therefore by definition off the wall. Okay, right. But this is not based on the character of the claim. It's based on the sociological phenomenon of being in a profession of people who claim or believe that they're engaged in reasoned debate. Okay. So then the next point is that the system is not simply one that's a level playing field of bunches of people who all think they're all reasonable people. It's rather a highly hierarchical structured system in which there are people with greater power and lesser power. The power can be political, it can be juridical, it can be the power of being famous, it can be the power of being rich. There are all sorts of what I would call nodes of power in any social system of people. And so a great deal matters is who takes a certain claim and asserts that it is reasonable. So in other words, it's really the nodes of power in a society are basically the creators and perpetuators and reproducers of the notion of what's a reasonable legal claim and what is off the wall. Okay, so that's the second idea. Here's the third idea. Well, what if it turns out to be the case that someone wants to change notions of what is a reasonable claim? They want to move something from what is completely off the wall onto on the wall, which doesn't guarantee it becomes orthodoxy, but at least guarantees that it's something reasonable people can disagree about. And of course, if you get far enough, then to disagree with it would be off the wall. But here I'm only interested in how it becomes reasonable. And that has to do with whether or not you can get people to say, this is a reasonable claim. This is not crazy. This is something a reasonable, sensible person could believe. And here now you see the hierarchical structure of reasonableness and the nodes of power become very important. So I love to tell this story about this. So in 1971, in a case called Baker versus State, Michael McConnell, not to be confused with Michael McConnell at Stanford, Michael McConnell, who was a member of a same-sex couple, was trying to get Minnesota to recognize marriage between him and his partner. And he was also a lawyer, and he took a claim all the way to the Minnesota Supreme Court, Baker versus State, is what the case was. And he argued the case based upon theories of sex equality, which hadn't even been recognized by the Supreme Court yet, right? But this is 1971, so this is, right? And so he argues in front of the Minnesota Supreme Court, and one of the judges is so offended by the fact that he would make such an outrageous argument that he wheeled his chair around and refused to face McConnell as he made the argument. That is 1971. By 2015, the Supreme Court has decided Obergefell v. Hodges, which basically says it's not only off the wall, it is the law of the land. What happened in the interim? Well, it took a very, very long time to move claims about same-sex marriage from being absolutely bonkers crazy off the wall till they could even be considered something reasonable people could disagree about, and then finally it could become the law. Very important. So what did it take? It took mobilization, it took a social movement, it took influencers both in art, in culture, in politics, social mobilizations. All of these things were basically engaged in making use of the various nodes of power. But since this is a gay rights movement, they really had to start from nowhere, right? And they had to start from scratch, and they had gradually had to build their way into these various nodes of power in sociological terms, to basically make people believe that this was an argument that a reasonable person could take seriously. Now I'm going to contrast that with another story. In 2000, December of 2000, George Bush was in a pretty pass. He wanted to basically prevent Florida from recounting the votes. He was fearful that if they recounted the votes under the rules of Florida state law, that in fact he might in fact lose the recount, and then Al Gore would become president. And so he had to find some legal theory that would convince the Supreme Court, the Florida courts, and then Supreme Court, to stop counting the votes in Florida. And they came up with a theory. And the theory was a theory that no credible Republican would ever have adopted, which was to expand the protections of the Equal Protection Clause to protect voting rights, which was, completely that Republicans don't do this in 2000. Right. But, anything in a crisis. So the lawyers got to work and they came up with the theory, and then they began to do it. And this argument was completely off the wall in November of 2000. And yet by December of 2000, it became the law of the land. What was going on? Well, it's a completely different configuration of nodes of power. First of all, an entire political party got behind the argument. And moreover, there were 5 justices on the Supreme Court of the United States who had been appointed by Republican presidents. So when you put together the particular power configuration and the fact that people got behind it, very important and powerful lawyers got behind it, Ted Olson got behind it, then what you got was it moved very quickly from off the wall to on the wall. So what's the difference between the gay rights movement and Bush versus Gore? Power. Sociological power, and its notions of constructing what is reasonable or not reasonable. So that's the short answer. And I could also tell you different rules about Obamacare. That's a third example, but you get the basic idea. So when you ask, how does everything that is solid melt into air from the standpoint of legal certainty or constitutional certainty, I would say look at the structure of not only discursive power, that is, or artistic or cultural power, but political power and economic power in the United States. Where is it lined up? Who is willing to make a claim? Who is willing to put their reputation on the line as saying, yes, this is a reasonable argument. Not only is it a reasonable argument, it's the best argument. And you're wrong to suggest otherwise. And so it's this configuration of cultural, political, economic power that has basically unsettled the whatever consensus we had before.
Mm-hmm. Mm-hmm. And when, of course, the court put that equal protection argument on the wall, they did it with that little kind of sticky tape that falls off after one case.
Quite only, as Owen Roberts said about the white primary cases. But anyway, the point is that, but that's not just simply about sticky tape. Think about the unitary executive theory, which we were talking about earlier. The unitary executive theory was backed by legal intellectuals, but legal intellectuals aren't enough to move something from off the wall to on the wall. They have to be connected into a network of other folks in politics and then in political power. So the Reagan administration really thought it was important to push this, I'm going to use a technical term here, Verkachte theory. Yes. Why? Because at that point, something like that. Meshuggah, no, Meshuggah. That would be Meshuggah. Anyway, so the point is that when Reagan is elected in 1980, he's surrounded by a civil service and an administrative state that has largely been appointed by the people of the opposite party, most of the liberals. And Reagan needs to make change, and he has to get his arms around this state. And the way he does it is by concocting, based upon quotes from Hamilton and others, a theory of the unitary executive. So it isn't from the 1790s, it's from the 1980s. But of course, as the social movement, the conservative legal movement and the conservative movement develops, this becomes part of the catechism of this movement. And therefore, as this movement gains power, and then it's on multiple fronts. It's in political, legal, academic. People write articles. Steve Calabrese writes a book about the unitary executive. John Yoo writes about the unitary executive. And so what you have is a complex of intellectuals, party folks, politicians, etc. And this is what makes it powerful.
That's really, yes.
So do you have a question? For
And since you are a sociologist by
I
training,
want to ask more questions.
since you're a sociologist by training, I thought that you would
I
immediately
was
see
kind of
this
hoping you would give that answer, actually.
as a
And
sociologist.
leading into, and you started with unitary executive, but where are we, what's going on now? I mean, it feels like the constitutional change, the things you've talked about are sort of discrete movements where you could see them coming from a long way off, where, there was a kind of run up where you could predict this was going to happen if you were paying attention.
Mhm.
And now it feels, I think, to many people like the bottom's just fallen out of the Constitution as we knew it. And so much is happening at once. And the court, I mean, we've all been in conversations, right, where people say, do you think the Supreme Court is quote unquote doing law? Right?
Yeah, they're doing law as much as other courts have been doing law, but that's
Okay,
not the.
so where are we now? Because it feels like it's not just one movement, right? But it's like. it's a
So,
whole
if you
configuration.
watch one of these elaborate fantasy dramas like
Yeah.
Game of Thrones or something like that, you realize that everybody has their own agenda. And then sometimes the agendas collide and sometimes they work together.
Yeah.
And that's what's going on. There are multiple agendas going on. So in the world of the Supreme Court, you have folks that were appointed years ago, many, and they were part of the conservative legal movement. The conservative legal movement has its agendas. Its agendas are the weakening of the administrative state, the strengthening of the presidency, right? And the protection of Christian conservatives. So this is a religion. The end of Roe versus Wade, the end of affirmative action. If you would ask somebody to make up a checklist, I'm going on the Supreme Court. Oh, here's your checklist. Would you please? It's like a laundry list, or it's like a grocery store: milk, eggs, sugar, affirmative action, right? So anyway, the idea is they've checked most of the stuff off the list by now. So that's one thing that's going on. And that's all done through law. It's all done through legal argument and all that, right?
Yeah.
Then there's Trump. So Trump is not the same thing as these guys.
Yeah.
You see, they have their agenda. Their agenda is the agenda of the conservative legal movement, which really goes back 30, 40 years. And he just happens to sort of intersect with it in different ways. So for example, he wants to empower the presidency. They want to empower the presidency. He wants to weaken the administrative state. They want to weaken the administrative state. He wants to use religion as a tool, as a cudgel. Well, they want to protect Christian conservatives. So it turns out there's some nice, there's some nice overlap, but there are things in which they don't agree about at all. And so then what you can see is he's getting resistance. And the resistance is not, in other words, he's not winning everything he wants to win. And so it is a clash of agendas that appear to be consistent but are not fully consistent. And in the meantime, what else is happening, and this also leads to the notion of confusion. Do you vaguely remember what the left was like in the late 60s, early 70s?
Yeah.
Do you remember there were Maoists and there were
It was disorganized.
it was totally disorganized. There were so many different versions of the left.
And the left is still like that in every country.
I understand
know,
that.
Right.
But what I'm trying to say is that sort of mannerist phase of left politics is what is now happening on the right. So what we're seeing in the discourses and intellectual life of the right is an amazing combination of variegated and motley ideas. You have people who said, "Oh, finally, Hayek will get his due." And then there's the Reagan, there's the old-fashioned Reaganites, and then there are the integralists and the neo-monarchists and and then there's the old-fashioned white supremacists, and now the newfangled white supremacists and the anti-immigrant folks. And you see what I mean? It's not a single thing. It may appear that way from the left, but it's actually a motley crew of all of these different right-wing crazoid ideas, which are now, if I may use the expression, emerging out of the woodwork, like termites for the purposes of constitutional law. Of that wall. And anyone on the left who watches this thinks, Is Adrian Vermeule on the phone to Neil Gorsuch? Is that what?
Yes.
No, he's not. They're completely, they're different parts of
John
conservative.
Finnis
Yeah.
links them all.
But
Okay.
you see what I mean? So that's
Yeah.
what's going on. And so that's deeply confusing. Not all of these forms of right-wing thought are going to make it onto the wall.
Uh-huh.
Only some of them. And the way you would tell is by looking closely at the nodes of power in society.
You've actually, so I have an article half finished, which I will finish whenever the Hungary stuff dies down, and it's called Trump is a they, not a he. And it's really about.
That would make sense.
Which I would love as a title if somebody would use it. But it's like exactly about the different strands going on, that are so far not, I mean, you could see them. I mean, for example, when Doge came in and started destroying the administrative agencies that Russell Vogt actually wanted to keep intact to do things with.
Right.
You could see that was sort of a clash, and we're seeing some other clashes in the
And
movement
Trump
as well.
is great because, of course, Russell Vogt is a Christian nationalist. He's a deeply conservative guy, but he's not Trump.
Yeah.
He's a guy with his own agenda.
Yeah,
Trump put him there. He's now carrying out his agenda.
Right.
Elon Musk is not Trump. Elon Musk, well, he is insane, but aside from his insanity, he has his own agenda, which is not Russell Vogt's agenda.
Yeah, true.
You see?
True. All the white South Africans that are being given asylum. Yes. But okay, so so you just said that you think that the court is still doing, the kind of Reagan agenda.
A version of
Mostly
it.
Reagan agenda stuff.
It is, I would say, the legal agenda of the conservative legal movement from the 1980s forward.
Yeah, but so then how do you explain? I mean, and you say the court's standing up to we can discuss
Well,
when they're
standing up is
standing.
the wrong word. They are wielding their influence in the ways they can wield it.
Yeah, so then what's in it for this kind of conservative legal movement stuff to completely kneecap Congress? The president can dissolve, look at the shadow docket decisions, which we think foreshadow at least the merits cases. He can dissolve agencies, he can lift the civil service law, he could fire anybody he wants, he doesn't have to spend money that's appropriated regardless of the statutes that have been set up. That strikes me as being way more extreme than anything the conservative legal movement stood for. And then also kneecapping the lower courts.
Yeah.
Right? Like, never mind that you have, disobeyed the orders of lower courts. We're just going to chop them off at the
Here,
pass.
I think that I think this is all new stuff, and I think it's tied to the phenomenon, which is the cult of personality that is Trump. That is, the Republican Party had wanted to do a whole bunch of things for a very long time, and they were unable to get over the hill. They tried it with Gingrich, unable to do it. Tried it with George W. Bush, unable to do it. And they kept trying, and they were never quite able to achieve a real transformation, constitutional transformation. And then along comes this guy, who's not even a Republican, and he's a crook, and he's a carnival barker, and he's a misogynist, and he's
a blasphemer.
and a racist, and somehow he connects with large numbers of people, and they figure they can ride him to power, and they can essentially they can achieve their goals, which is lower taxes for rich people and all the, deregulate, get rid of environmental regulation, all the stuff that's on the wish list. But the problem is that once you put him in charge, he now has his own efficacy, he has his own form of power, and that basically binds you to him ever more closely. And so you're afraid to do anything. And as a result, we have like a parliamentary system, a sort of rump parliamentary system.
You don't think it's just a monarchy? No,
even though, in fact, I don't think they wanted that. I mean, I'm sure the folks in the Senate and the House did not want to just be the vassal of Donald Trump. But the problem is they understood that the way the primary system works and the political system works, they had to be his vassal. And as a result, basically, they ceded all of their power. Even though these were the same people, by the way, in the appropriations committees who would have gone apoplectic if the president tried to interfere with the compromises they made over appropriations. But now they can't do anything about it.
Okay, so then this is sort of a puzzle, right? So if this was this conservative legal movement, there's lots more of them than there is of Trump.
Yeah.
And Trump is
So it's like a Jackie Chan film where Jackie Chan is in the middle of thousands of thugs, and you go, well, they got to be able to get him, right? No. He takes them down one at a time, right?
Okay, but so then this is right. So Trump is a lame duck. He's also patently crazy. I mean, just that, I mean,
Oh, you noticed.
led us into a war. I mean, he's getting, shall we say, more and more off the wall, like the wall's not in sight
No, he's
anymore.
becoming unhinged.
He's becoming unhinged.
So what would you predict,
So what
given
you would-
everything I just said?
So what you would think is that they would start to find their sea legs, or whatever metaphor we want to use.
Yeah.
And they'd rise up against him, but they seem to be quitting, right, instead. And we
Well,
don't see that happening.
So what I would predict is the following. Again, we're no longer talking about constitutional law. Now we're just doing raw politics. So forgive us for this.
Well, but
we're
I'm
really
wondering
talking
if
about
that's
this-
all that's left.
But it's the
right?
structure. It's the structure of political competition, I guess we're talking about. So I think the most important thing to ask is, after the primary season is over and the candidates are fixed on the
Mhm.
Republican side,
Mhm.
and then they actually have to win the general election,
Mhm.
then I think it will be very interesting to watch how much they're willing to distance themselves from him,
Right.
to the extent that he becomes more unpopular even in what used to be considered his base. And then do they start triangulating? And I don't know the answer, but that's what I would look for.
Right. But here's where the Supreme Court comes back, if we can add a little bit of
Yeah.
court drama. The court has already basically said, if they follow through on the merits with the shadow docket cases, that if Congress gets its act together, it will not be able to constrain the president, right? I mean, one way to read the immunity case is that Congress may not constrain the presidency with criminal law. One way to read some of these shadow dockets is they may not constrain him with civil service law,
Mhm.
or by saying that there must be some kind of reasons for firing executive branch employees, or that he can't just have his own reasons for refusing to spend, or for that matter, spending. I mean, think of the spending already on the Iran war,
Yeah, yeah.
which is not the subject of appropriations, because we've never had a war done with through appropriations, right? But only through after the fact,
Right.
whatever. I mean, that basically, I'm not sure Congress has any power left to work with, given the way the court has gone.
Yeah.
And so then why, I mean, what happens then, right?
So again, we don't know exactly what's going to happen. There are a bunch of different pathways. One pathway is that if you get a change of control of Congress, then it's possible that there will be different kinds of I'm sorry, if you get change of control of
Yeah.
Congress, there'll be different kinds of power of moves that you can make. It's also possible that I think in one of those Scheppele cases, it was that there was nobody who had yet to have been found standing, had standing to contest the appropriations, but depending upon the composition of Congress, there might be somebody who has standing, so they would get past the standing problem, right? So that one possibility is, in fact, the Supreme Court is just telling us, wait, we'll get to it, and we'll get to it in a different situation. The other possibility is that one day Neil Gorsuch will wake up and go, holy hell, what the hell did we do? This guy is insane. And then they'll start engaging in a kind of
And it was the tariffs decision. That was a big moment. okay?
No, it was not a big moment.
well,
Okay,
no,
so-
but I just want to say, we don't know. In other words, I'm not going to tell you I know what's going to happen. There are all sorts of pathways of things that might happen. But I think what you're most concerned about, and this is what I want to lean into, is these eggs have already been scrambled. And so the next president, whether Democratic or Republican, will have free reign over the structure of the executive branch, and will have powers that no previous president had before, with the blessing of the Supreme Court, and will have immunity that no president had before with the blessing of the Supreme Court, because that was actually on the Republican checklist. I mean, they really wanted all that stuff, and so they got what they wanted. But when they decide the case involving the FTC, and also the companion case involving the Federal Reserve, they're going to face a bunch of very difficult problems they never had to face before. And those problems are all outlined in Justice Breyer's dissent in the what's the name of the case? Oh, it's
What's the topic of the case?
it's the dual protection. Peekaboo. It's a peekaboo case. So the peekaboo case, it's a long dissent in which he says, I know what you're up to. I know what you're trying to do. And just let me now give you a laundry list of all the places where if you really tried to apply unitary executive, you'd create a mess of problems. And so that was just lying there. It's been lying there the whole time since the peekaboo case. And Now they're going to have to confront them
Yeah.
in the FTC case and also the case involving the Federal Reserve. So we don't know quite exactly how they're going to calibrate them.
Yeah.
And so that will be important. But I think at the largest level, I mean, at the big level, that it's just done. These eggs are scrambled. You're not going to get back to the pre-20th century conception of the administrative state.
So instead of morning in America, we're going to have breakfast in America, right? With your scrambled eggs. So here's the question I have about this.
If they cook the eggs, yeah, I mean, otherwise it'll be raw.
But since we have a person in
Yeah.
charge of public health who believes in raw food, maybe it's not a problem. Okay, so
Yeah, that's, by the way, another set of agendas which are not Trump,
right.
right? They're just floating out there. Yeah, go
Okay,
ahead.
so here's where I want to ask you something because as you know, I sort of fled America after Bush v. Gore, and I've refused to teach U.S. constitutional law since that time. Long story, but I started when Ruti and I met. I was working at the Hungarian Constitutional Court in Hungary. Then I went on to work at the Hungarian Constitutional Court in Russia. Those are both just packed courts that are dead. So having had experience up close with packed courts, like broken clocks are right twice a day, or they don't rule against the autocrat all the time.
Right.
And in my experience with these other packed courts, there are three kinds of occasions. I'm writing this one up too. You're getting the previews of everything I haven't written yet, but there's three occasions on which packed courts stand up to the autocrats. Okay, right. So one is when the autocrat has gotten himself into a cul-de-sac and he wants to turn around without turning around because backing down is what autocrats never do.
Right.
A court will conveniently declare something unconstitutional in order to give the executive an easy way out. And then the court says, see how independent we are. And the executive says, you see, I'm following the rule of law, like we are still in rule of law land, not to worry. Okay, see National Guard case.
Right.
Right? They waited until he had no more use for the National Guards. How was he going to pull them out of LA and of Chicago?
It's
And
also ex parte endo, by the way.
yeah, it could be also, but I mean,
Yeah, and the
that
Japanese
court-
internment.
That court also was, we could say a little leaning toward executive compliance, but anyway, so that's one kind of case. The second kind of case
No,
is
because
where
remember, endo is the companion case to Korematsu.
Korematsu, right?
Right.
That's the good case, right? So,
Or bad, depending upon your view.
No, bad.
There's been a writ of error coram nobis afterwards, and so we know that the facts were all,
Yeah, we're all-
misrepresented to the
Exactly.
Supreme Court. They're very important to teach that.
right. So, yes, exactly. But I'm just saying that, if we look at the current court and where it's standing up to him so far, the one is the, cul-de-sac and backtracking and that. But the second case, again, looking at my other courts where you see courts standing up to executives, are in cases where the court is coming in for a lot of criticism. People are wondering if it's still doing law. It wants to appear to be doing law, but it doesn't really want to stand up to the executive. So it will stand up to the executive in areas where the executive has done A, wants to do A, but there are multiple ways of doing A. So what the court says is you can't do A that way, but there's some other way you can do A.
Yeah.
C tariffs. That's where I think tariffs, and they even say in the opinion, there's like all these other avenues, right, that you could use to do tariffs. if you
Sandy's
really
and
wanted.
my constitutional dictatorship. There are just 50 different ways to get.
Yeah, but I mean, they didn't block tariffs. They just blocked IEPA tariffs, and actually one thing I was watching while the case was pending was look at all the tariffs Trump was ranting about, like China and Britain and the UK and Canada. He had already moved those under the other authorities before the court made the decision.
Yeah.
So they basically got rid of the tariffs on penguins, a few other things too, but I mean, the big ones.
And the
that Trump-
penguins are very thankful.
Penguins, look, I'm all for penguins, but the point was by the time they decided the case, Trump had moved the tariffs he most cared about already under those other authorities. So how is that standing up? And the third kind of case that I've seen, again, from looking at other courts where courts will rule against an executive are sort of big human rights, constitutional rights cases, which generate a lot of interest from the general public, but where ruling in favor of the executive would really make everyone realize this court isn't functioning. And so they look for cases like that, but where ruling against the executive doesn't really interfere with the consolidation of executive power in this core sense. And that's where I think birthright citizenship is going to
I
be.
think that's probably right. I mean, it's
So-
overdetermined. It's overdetermined that birthright citizenship is going to come out against it. But there are all interesting questions about how they're going to do it.
Yeah, no, and I'm not complete. I'm not convinced it's going to come out completely against him, frankly, but
Well, yeah,
in any
right.
event, I mean, that's what I've seen from other courts. And so I look at this court and so far it's just all the cases where they're standing up to him. And I guess I'm wondering whether you still, I mean, you thought Gorsuch would wake up and think, oh my God, or Roberts, we've been thinking the institutionalist. Where is he? But when you read the immunity case and they say,
Community case it's really the wish list of an earlier conception of a Republican president.
but it's also like you can set the Justice Department against your enemies, even while we're immunizing you, right? That was the point made in the last panel. So I guess I'm wondering why you think we're still in a space of constitutional law at all.
Oh, we are in
We'll
it.
open it up.
We are in a
Okay.
space of constitutional law and just not one you like. I mean, do you
Well,
mean?
is it law or is it only politics? Is there anything to be said for there to be any, I know you've always been on the politics side of that, but even you sort of thought the court would come around. And do you think there's
No,
any
I mean,
law left?
when did I say I thought the court would come around?
Gorsuch would wake up and decide
No,
that
I
they-
mean, but you were thinking, I'm thinking some of them, they will find that some of the things Trump wants to do are inconsistent with their agenda. And
Yeah.
then they will,
Okay, but is there a they really that is
Yeah.
coherent on this or?
there is a conservative legal movement agenda.
Okay,
It was handed out to everyone. You didn't get the memo? There were a bunch of things on the
I was abroad.
list. You were abroad. No, I got it. I mean, I show up at Federalist Society meetings. They gave it to me. I looked at it. I said, oh yeah, that's going to happen. Right? So,
Yeah.
but it's not, the point is that Trump is athwart some of the goals of the movement.
yeah,
And the justices are life tenured and they are not his stooges.
Mhm.
In other words, this is not like the situation in other
Yeah.
situations. And so they actually still represent the values of this movement. Now, there are a couple of the justices who really are Trumpers. I mean,
yeah.
but the other conservatives are not.
Okay, on that.
Yeah.
note,
Two questions.
Okay.
Mark and David and John. Okay, three questions.
I think because they like.
Okay. Yeah, I can hear you.
I'm wondering off of what Kim said.
Recording.
Oh, okay.
Okay.
Now, you realize it just became, I was going to talk about high theory and constitutionalism, but you didn't want to talk about that. You just wanted to talk about nitty gritty of.
It left the postmodernism. I gave you the explanation.
Okay, fine.
Your blue
Okay.
period.
Reporting for posterity. I'm
Okay.
wondering, Kim, whether we could summarize your things authoritarian courts do, particularly in democracy, is one of the functions of the Roberts Court is to sanitize the administration, that when, particularly if a character like Trump, who believes in his infallibility, and threatens with tariffs to weaken a crucial Republican bloc, such that if they lose that bloc, they're hopeless. The job of the court is just to say, nope, we'll set limits in the name of the Republican agenda.
Mhm. Well, I'm,
Okay, hang on.
Okay,
We're gonna go
okay.
three questions.
okay,
John,
okay.
And then David.
Do you need a?
No? But Jack?
In 2022, we set the precedent that this country can have 10 commissioned Supreme Court justices. So when Jackson was confirmed and commissioned and Breyer had not yet left the court because he was finishing the term. So if the Democrats win the Senate this fall and have 51 or more seats, and Thomas and Alito then offer their resignations contingent on the confirmation of their successor and whatever future event, like 2 more years, and the lame duck Republican Senate then confirms, 2 33-year-old circuit judges, Eileen Cannon, whomever, really tries to pack the court. What's the power response, the law response that constitutionalism should then take?
Just very briefly, I'd be interested in what your thoughts are on what the role of legal academics is with their scholarship. The role of legal scholars are. Randy Burnett and Elon Werman came up earlier today, which I think people think of as just results-driven scholarship. then there's sort of the view that you just write about what you're interested in, ideally as far removed from current situation as possible, so as to not sort of corrupt your thinking. And then, Jack, I think you were saying you think about your scholarship somewhere in the middle, where it's relevant to today, but it's not driven by some particular political outcome. I might be mischaracterizing what you meant to say, but I was wondering what your thoughts are about what our role is in relation to the discourse, Supreme Court decision making, and so on. Thank you.
Which one are we going to do?
Take your pick.
6 minutes.
Oh, yeah, I honestly don't, I honestly don't know what goes on in that hypothetical, where you basically create the excess commissions. And I honestly don't know. I don't know whether the commissions are valid if they go on past a certain amount of time. The Senate, as you know, is a continuing body. So it's not like the House where something can expire. So I honestly don't have a good answer for you about what that happens. I mean, it is hardball. It's an interesting new form of hardball, and people could try it. The question is whether or not it would gain political acceptance. So the answer is I don't know. Mark, what was you're asking? Yeah, I mean, I think that a lot of what the Supreme Court tends to do with respect to the presidency in general, not just with Trump, but especially with Trump, is to sane wash it, is to basically treat the president as if he's not nuts, but is rational and has policies. And that's what happened in Trump versus Hawaii. I mean, Trump versus Hawaii is judicial sane washing of what Trump was doing. And I think that's just basically their modus operandi. I think it also has to do with the fact that not all of the justices, but a healthy number of the justices work in the executive branch. And whether or not they like Trump, they have a deep respect for the operations of the executive branch and therefore tend to treat it as presumptively legitimate. And therefore, a lot of what they do is basically make excuses for the executive branch, whether or not they're Republicans or Democrats. I mean, this is what's interesting. And that's why I suspect you'll find that Ketanji Brown Jackson, who did not serve in the executive branch, she was a public defender at one point, and she was on the Sentencing Commission and other things. She just doesn't come out of those traditions, and so she just has no patience for the kind of sane washing that is routinely done by justices with respect to the executive branch. What is the obligation of legal intellectuals? Well, you're not going to believe me when I say this, but it's to discover what is true about the legal world and report on it and offer theories.
Postmodern Jack.
And offer theories about it. Yeah, I mean, truth is a primitive.
Yeah.
You can't do without it. There's nothing, as Sandy likes to say, quoting Ruti, there's nothing more interesting to say about truth other than some things are true and other things aren't true. And so that's what they do. They're intellectuals within an academy, and their first duty is toward truth. Now, of course, you have disputes about what legal truth is. It's also true that many lawyers are politically active and align themselves with particular causes, and as a result, their conception of what the best continuation of the law is not unaffected by their political allegiances and alliances and the goals they want to achieve. Then we can talk about particular cases of particular people who've taken off-the-wall positions. Randy Barnett is a very old friend of mine. We've been friends for 3 decades or more, and I'm not happy about the fact that he and Elon, did this, and I'm not happy about the position he took. But, there's not much more I can say about it. I disagree with lots of my colleagues. A lot of them take positions that I don't think are sustainable. In this case, I find the particular position they took to be deeply offensive to my sense of the meaning of the United States. But that's about ethos in politics, about the meaning of America, as opposed to a particular argument about the niceties American law.
Well, could we talk about that?
Yeah.
Because I didn't pose a question, but I do think there's a question of people's understanding of the ethos and what that has, some sense of solidarity with others and how polarized the US is. And so whether there's, that normativity, where is that supposed to come from? I mean, Sandy wrote about constitutional covenants. If it's not, a shared, any other shared normativity, let's say some liberal religion where that, the golden rule reigned, where can that be advanced or promoted? What is your thinking, both of you, on that, on this issue of the ethos?
Well, I mean, it's probably a bad idea to try to search for some set of propositions that all Americans can agree on.
I understand.
That probably will not work. And of course, the birthright citizenship example is a perfect example of why that's probably not a good thing to search for, because you'll always be disappointed. Someone will always break your heart with respect to some thing. Yeah, right. I think instead of thinking about it in propositional terms, I think you should think about it in solidaristic terms. That is, in terms of, how do people identify with other people as being part of the United States? Yeah. And the dangers that we face now aren't that people believe crazy things, because lots of people believe lots of crazy things all the time. It's that they tend to have lost a sense of a common project, which is America.
Right.
And that is the danger signal. And I'm not going to sugarcoat it and say, oh, it'll all be fine, and it will get through this, everything will be fine. I'm not sure everything will be fine this time. I hope everything will be fine this time, but I'm not sure about it.
Well, in diverse societies, let's say confederations, now in other Israel-Palestine, they're looking to the US Constitution, I kid you not, as an example of a confederation, that and the EU. The notion of diverse, peoples, how they can, stay united, and of course we've had our periods of division, right? And so we may be heading into one of those. Is that part of what you're thinking or not?
Well, we already have a confederation.
No, I know. I'm saying what part of this do you think could be, I don't know, reinforced or be part of the ethos? I don't think most people think of us as I don't think that in public education or even in law school that we're teaching the US Constitution as a confederation model. It's not taught that way.
No.
Absolutely not.
I know it's been increasingly nationalist over the course of the country's history.
So I guess maybe it would be a good thing to recognize our diversity and to talk about the supremacy clause or what, the areas where we're connected, where
I don't want to sound Pollyannish, and so please understand what I'm saying with a grain of sourness, okay, or pessimism. And I'm going to use the term advisedly, the genius of the American constitutional system has been its amazing flexibility and its amazing adaptability. Exactly the opposite of what my fellow originalists ordinarily like to think. I mean, I regard it as a feature of the original plan that it be highly flexible and adaptable, and so that it can actually be consistent with many different social formations. Some social formations that are more decentralized and dispersed, and some that are more unitary and centralized. And it may well be that the strains that we're going through right now demand a reformation of political and social formations to take the pressure off of the very hard choices we've been faced with in the past couple of decades. So but another thing is
take a page from other confederation models.
But even at the same time, nobody will ever say it's a confederation.
No, they don't.
But in other words, it will be adapted to that thing. But the other thing you have to realize that's going on, and this is, the United States always benefits in some ways from its own misfortunes and its own mistakes. So in the Cycles book, I make this counterintuitive claim, and we'll see whether it's true. The counterintuitive claim is that during periods in which the United States gets into paroxysms of anti-immigrant sentiment and closes its borders and drives people out, it has a bizarre counterintuitive effect. It creates a demand for redistribution. It creates a demand for redistributive politics. You would think it would be the other way around, right? More immigrants.
yeah,
coming in.
no. You have to
The more who's the community is, the more they have social welfare system. I mean, that,
And so there is a sense in which there's-
now when they have immigrants, they
Right.
don't like it so
So,
much.
Exactly.
so what you get is the borders get closed more or less really after World War I, and then they really get closed after 25. And then what you see is you get a real push for redistribution. And then, of course, we, see the better angels of our nature. And in 1965, we rethink our attitude about the rest of the world. And for a period of approximately 60 years, we have basically been getting the best of the world. I mean, forget what Trump said coming down the escalator. We have been benefiting from all these wonderful people coming from all over the world and getting the benefit of their talents. And now we're in another paroxysm of anti-immigrant sentiment, and we seem to be wanting to close the borders again, and that has this strange effect. So if I were going to predict something, I would predict that if Trump gets his dream wish and the borders get closed, then the rest of the Republican Party will not be happy because there will be a huge pressure for redistribution.
Interesting.
So thank you for this conversation.
Jack, we have 6.5 minutes.
For closing, because the wine's being chilled, Jack, and we have to finish at 6:15.
I'd want to thank you all for coming. This means an enormous amount to me. I wish all of you have a day like this in your lives, when people say nice things about your life's work. I hope everyone gets the benefit of such a wonderful day, and it has been a wonderful day. And so I thank you all for coming, and I thank all of you for staying the whole day. I mean, you were here at the very beginning, giving the keynote address, Mario. So thank you. God bless you. And so I just want to tell you how grateful and much gratitude I had. And I want to thank everyone in this room, and I could spend hours thanking each and every one of you, but I do want to thank Penny, because she was He's the most amazing impresario in putting different folks together who usually don't have conversations with each other and managing what I think has been a wonderful conversation. So thank you, Penny, and thank you all.